Here we go. This is like a soft open for the new show. For those of you who don't know me, I am Matt. If you are tuning in for the first time, this show used to be known as Why Libertarian. But like I said, we're doing a little bit of a soft open here. So this is going to be the new format. It is called Ungovernable. And so our official first episode will be taking place on July 12th. And we're going to be talking about deschooling your kids. Not unschooling, not homeschooling. We're going to be talking about deschooling. So definitely check us out. Put it on in the calendar. Subscribe to us. And tonight we're going to be talking about natural rights. So you're more than happy to take part in the conversation. So make sure to like and upvote the broadcast. Help us with the algorithm. Definitely subscribe. And like I said, you can share your comments and questions while we are on the live feed, and also share this out there, retweet it, help us kind of broadcast some of this message. Myself and Dave are really looking forward to hitting the ground running on the 12th, talking about deschooling. But so, as this is kind of like, the second generation of the show, some things have gone away and some things haven't. And so I am going to continue to bring you and work with this person talking about natural rights, because it is extremely important in terms of a baseline set of knowledge for folks moving forward, especially if they want to preserve and even recapture some of their liberty and freedom in this lifetime. So without further ado, welcome back Josiah Hinkle from the American Natural Rights Foundation. How's it going, Josiah?
Good, thanks. How are you doing, Matt?
I am very good, very good. You are you're the lucky guinea pig here for the first, like I said, soft open for the new concept.
Awesome. Sounds good.
So it's been a couple of weeks as I kind of work through the formatting and the branding and stuff like that. So thank you very much for being patient and kind of sitting on the sidelines for a little while I got my ducks in a row. But
No problem.
So tonight we have. Oh, go ahead.
No, I'm sorry. I was gonna say it actually made it made tonight's presentation better. Something happened in the interim that I included in there. So
lemonade from lemons. That's good. So tonight we are talking about, let's see, Habeas Corpus, jury nullification, Esprit de corps, which is a fantastic phrase, and I've heard it so many times. And as I read through your notes, I realized that I didn't know what it was at all. So we're going over that as well. And then finally, we're going to sum it up with the overarching mission of the American Natural Rights Foundation, and what you're really going to try and accomplish here into the future, which is absolutely fantastic.
Yeah.
So let me throw my notes sheet up here.
Okay.
If I can get the right one. All right, here we go. All right, so we are kicking this off with
just before you start. Sorry to interrupt. I just wanted to remind everybody, because it's kind of been a few sessions, but I just wanted to remind everyone that I'm definitely not like an expert. I'm not an expert in history or in law. I'm not a legal professional of any kind. So while the information that you hear in these podcasts is to some degree inarguable, and it's to a limited sense it's been verified, it represents the information that we're currently trying to research and kind of field out.
Fair enough. Yeah, definitely in any of these situations, if you have a question about legality, hit up a lawyer. They get paid a lot of money for a reason. So some of the things that we some of the things that we talk about, they probably shouldn't get paid that much money, but in the current system, that is the space that they fill. But so that being said, we're starting.
It's kind of hidden from the legal profession, to be honest.
Yes, I intentionally, right? Or would you say unintentionally or intentionally?
I think kind of both, hand in hand, because on the one hand, as a profession, it's unnecessary. You can't do anything in the law. You can only do something in equity as a lawyer. But on the other hand, obviously, there's an agenda with taking the law as a means of, remedy away from the people.
Fair enough. Yeah, no, a little bit of both, I guess.
Yeah.
So, I love this. So we're starting off this week with Thomas Jefferson and Thomas Jefferson, what, writing to James Madison?
Yeah, so in a letter that he wrote to Jefferson Madison from December 1787, it contained objections to key parts of the federal Constitution. So primarily, Jefferson noted that that a Bill of Rights, he noted the lack of a Bill of Rights and a specific enumeration of what he thought, might actually or should be included in it. So he said, a Bill of Rights should provide clearly and without the aid of sophisms for the eternal and unremitting force of the habeas corpus laws, and trials by jury in all matters of fact triable by the laws of the land. So what exactly is habeas corpus? Well, it's a Latin term meaning you have the body and is derived from a longer phrase used in medieval times, meaning you may have the person to be subjected to examination. So it's a legal process that guarantees that a person can only be arrested pursuant to the law and not simply at the will of some despotic governing authority posing as the law. It's a legal procedure in the form of a writ that demands that a person be brought before a magistrate and actually charged for a crime under due process, or else that he be immediately released. It protects the people by preventing government from making arbitrary arrests. So Jefferson would remark about habeas corpus in a letter to Archibald Hamilton wrote in 1798. The habeas corpus secures every man here, alien or citizen, against everything which is not law, whatever shape it may assume. So Jefferson essentially saw habeas corpus as like a catch-all for, the color of office that government agents often find themselves, abusing, basically.
Yeah.
Sorry, I'm just gonna have some water. So he even said in his first inaugural address, freedom of the person under the protection of the habeas corpus, I deem one of the essential principles of our government. So, let me ask you, do you know how to use habeas corpus? Or have you ever, do you know anyone who has used it?
Functionally, no.
Right. And yet, do you see how it's like an essential part of our government? Yeah. Isn't that crazy?
Wait, well, so, and it's an essential check, right, on the overreach of government, or the fraudulent use of the idea of the rule of law when truthfully it's an overreach. Yeah.
Yes, that's so well put. A fraudulent use of the idea of the rule of law. Perfect. Yeah. Yeah, totally. So, right. So essentially, if there's no case, the idea is that this process, this legal process, causes you to be pulled in front of a court to be determining whether or not there is enough evidence to charge you with a crime, and if not, then to release you. Mm-hmm. So he even discusses the suspension of habeas corpus in the manner in which Lincoln did it. I'm not sure if you're familiar with the fact that Lincoln suspended habeas corpus, but
I have heard that. Yep.
Yeah. So he, quote, "Why suspend the habeas corpus in insurrections and rebellions? The parties who may be arrested may be charged instantly with a well-defined crime. Of course, the judge will remand them, and that just means that they'll be taken into custody, right? Like if there actually was a crime you could be charged with. Mm-hmm. Examine the history of England. See how few of the cases of the suspension of the habeas corpus law have been worthy of that suspension. They have been either real treasons, wherein the parties might as well have been charged at once, or sham plots, where it is shameful they should ever have been suspected. Yet for the few cases wherein the suspension of the habeas corpus has done real good, that operation has now become habitual, and the minds of the nation almost prepared to live under its constant suspension." So Jefferson said that in 1788. Like, how long has it even been?
Yeah.
So it's the very beginning of the sophistry,
And the other thing I was thinking about was, there's a lot of people that were involved in some shenanigans on January 6th who might find this pretty interesting.
I know, right? That's what I was thinking actually when I was reading through that. That's funny. And also, I was going to say in a later episode, basically now with the people living under constant states of emergency, it is like basically the continuation of that.
Yeah. And really, to boil it down, what he's essentially saying is that if you suspend habeas corpus, or correct me if I'm wrong here, essentially what he's saying is that in situations where habeas corpus is not abided by or suspended, that there's typically two situations. It's one where it's completely obvious, and like suspending habeas corpus doesn't exactly do anything because the person would have, overwhelmingly had enough evidence to be charged with something.
Yep.
Or the other is the exact opposite awful scenario where
Right.
there's almost no evidence, right?
Yeah. The reason why habeas corpus was supposed to be used.
Yeah. Yes.
Yeah, exactly. So let's see. So in that same letter to Madison, Jefferson stated that what he would have liked added to the Bill of Rights. He said, the following clauses would have pleased me. No person shall be held in confinement more than blank days after he shall have been demanded and been refused a writ of habeas corpus by the judge appointed by law, nor more than blank days after such a writ shall have been served on the person holding him in confinement, and if no order given on due examination for his remandment or discharge. So if no order to remand or discharge was given after a certain number of days, then they should not be held in confinement. Nor more than blank hours in any place of a greater distance than blank miles from the usual residence of some judge authorized to issue the writ of habeas corpus. Nor shall that writ be suspended for any term exceeding 1 year, nor in any place more than blank miles distant from the station or encampment of enemies or of insurgents. So you can think of the mention of distance from the residence as like Jefferson sitting there, counting up the hours it would take, to take for a man to, ride from one place to another on horseback, right? And that being the only legitimate excuse for why a habeas corpus writ wasn't, taken to immediate effect.
Yeah.
Right. So, and like with all of this blanks, where he's saying you actually define all of these particular metrics, he didn't think it adequate to leave it to, a vague statement like expedient or as soon as possible, but rather literally calculating the hours it should take for, a man to move a piece of parchment from one place to another on horseback. I just think that's pretty remarkable.
Yeah.
So also that distance from the enemy encampment, you can think of that, or the encampment of enemies or insurgents, is basically what relates to, the real needs of fighting. So the idea of the enemy being picked up and then being able to use this legal process to free themselves so that they could just go right back to fighting is essentially why there's this argument for suspending it in times of that. But obviously, as Jefferson pointed, with the blank distance from their encampment, that's where it would lose its force. So
well, yeah, and if you think about it in the context of just post-colonial America, right? How long does it take you to travel from, say, New York to one of the Carolinas or vice versa? And that being said, if you were a part of some kind of insurgency or something, or if they wanted to allege that you were, and you're in New York, but the activities took place in the Carolinas, it would be unfair to essentially assume the ability to charge with a crime, or basically suspending habeas corpus if someone is essentially an unfathomable amount of distance away from where the encampment was, where essentially supposedly this insurgency took place. Is that kind of the equivalent of what he's looking at?
Right. Well, right, exactly. Like you're actually talking about a particular individual being picked up and then filing for a judge, to say, hey, look, I don't know why you picked me up. You have no right to pick me up. I didn't do anything wrong, and getting rid of habeas corpus that allows him to be released to then go back to fighting. Obviously, there's a particular logistical practicality to the application of that logic. Right? That as soon as you get a certain distance away, that logic completely breaks down, because what are we even talking about? Well, the person who you're picking up obviously isn't anything related to the enemy insurgents, the encampment or whatever.
Yeah. A month later, they're gonna take up arms again once they get back to where the insurgency is. Yeah. So
So this excerpt just shows the significance habeas corpus played in the protection against the arbitrary invasions of government, and that Jefferson was specifically concerned for the people's access to its legal process. And remember that that process to Jefferson is like a catch-all for the illegal actions of government. So consider that when we consider habeas corpus today. In 1996, Congress narrowed the writ of habeas corpus through the passage of the Anti-Terrorism and Effective Death Penalty Act, AEDPA. The AEDPA has three important aspects. First, it imposes a 1-year statute of limitations on habeas corpus, on habeas petitions, which means if you don't use it within the first year, then you forfeit the privilege to use the process. So we come from Jefferson actually calculating the time it should take for a man to ride from, where he is to the judge's house and then back again on horseback, to now having a means of immediate communication, right? Because we've got cell phones, we have the internet, everything like that. And yet, after being held illegally with no charge for a year, you now don't have this legal process that was literally there to allow you to protect yourself from the security of the arbitrary and illegal invasions of your government.
Yeah.
How ludicrous is that?
Yeah.
Like,
I mean, it is, how should I put it? I mean, it's essentially abuse of process is what it is.
Absolutely.
Or, I mean, maybe not in the traditional definition of abuse of process,
No.
but I mean, this is
It abuses
once
the
again
law.
one of those instances where the substantive law is essentially being ignored, and it's more associated with procedural law that it's being replaced with.
Honestly, when I hear things like metaphysical jurisprudence, I think of this as like metaphysical legislation. You know what I mean? It's just legislation that's like the IRC, the Internal Revenue Code.
Yeah.
It's there to make you it's there to make you go mad. It's there to make you have no sense of anything that it's saying. And it's like, you know what I mean? It's just meant to destroy all of your liberties without saying, hey, your liberties are to shit now.
Yeah.
You know what I mean? Like,
because this piece of paper says it.
Yeah. Well, because it says it so sneakily. Because if you don't know about habeas corpus, if you don't understand, and I imagine back then it was way more significant because you didn't have the identification system that we have today, right? So like when you were picked up and you gave a fake name and then they had to release you from habeas corpus, you were literally free again, probably. You know what I mean? Like they could not find you or know who you were, probably. I mean, to whatever degree, that can be practically true. But like now, obviously, we've got, all sorts of, I think they're illegal for them to have facial recognition and things like this. I don't think there's any legitimacy to that because nobody's done any particular crime.
Yeah.
You see what I mean? And it's this violation of the Fourth Amendment for them to try to identify you.
Not to mention the fact that I don't understand how they get away with, how there's a justification that that's not a legal search and seizure. Like,
well, remember, these are those, it's grafted on. You remember the the niceties and metaphysical jurisprudence that was grafted onto the system, essentially. That turns our beautiful system of law into this slavish, tyrannical system of abuse, basically.
Yeah. Most definitely.
So
secondly,
so second, unless the United States Court of Appeals gave its approval, a petitioner may not file successive habeas corpus petitions. So like you got a petition in with one court, right? Like how long does that take for that to get processed, right? And then you maybe find out that it doesn't get approved. Maybe there's like a technical defect, or, maybe you pissed them off and they sat on your paperwork, or, it just because, or maybe they say there's a huge caseload, right? So then how many of these only consecutive petitions can you even file in a year?
Right.
They're really just reducing all of the effectiveness that used to exist that protected people. You see?
Yeah. I mean, the biggest misnomer nowadays is protections under the law. I mean, there's under the present law, there are no
Well,
protections. Like,
well, I would have to argue with you because if you're a police officer, you probably got quite a lot of protection under the law.
that's true. Depending on what role you're in, yes.
Yeah, exactly. Depending on whose boots you lick.
Yeah.
So, but this one's the worst. Okay, so third, habeas relief is only available when the state court's determination was, get this, contrary to or involved in unreasonable application of clearly established federal law as determined by the Supreme Court of the United States. It's fucking despicable, isn't it?
Yeah, yeah.
Isn't that absolutely just like, you remember how we talked back, before about Taylor and how the Supreme Court was never supposed to have this final say on the interpretation of law, first of all, or on the construction of the Constitution.
Yeah.
So
Well,
this
and,
is just,
and the,
sorry,
their domain was essentially the operation of the federal government. It was not the operations of the actual states or the state court systems. Yeah.
Or the law. Yeah, exactly. The state court systems. Yeah, exactly. So yeah, just continuing here, the sources of habeas corpus can be found in the Constitution, statutory law, and case law. The suspension clause of the Constitution states the privileges of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the safety may require it. Although the Constitution does not specifically create the right to habeas corpus relief, federal statutes provide federal courts with the authority to grant habeas relief to state prisoners. See how far we've moved away from, what was it, securing every man against what is not law, whatever form it may assume, as Jefferson put it.
Mm-hmm.
Like, this is the most insane thing.
They've literally moved the they've also, like, this is a common theme throughout so much. Like, I mean, in the natural law, it's a common theme, and kind of like the construction of this country's judicial system.
Yeah.
But also in so many other aspects of life too nowadays, it has gone the same way, where they take the locale under which something is supposed to be determined, and just, like you said, metaphysically, for essentially, mysticism type reasons, move it as far away from where it was supposed to be determined, and place it in the hands of someone who is, unreachable, untouchable. Essentially the diametrically opposed. Like, if you can think of the exact opposite intent, like, that's exactly what they've done.
Like, this is why, I mean, not only the targeted and dedicated attacks over the last 2 centuries, but what you're describing is another reason exactly why I say we are at war. Like, we really are. And I don't know who all is on our side. When I say that, I mean to say, like, I don't know if it's just the American people who are being attacked. I'm under the impression there's quite a lot of people around the globe being attacked right now. So I don't know who all is on this side of the war, but definitely Americans are at war and have been at war for the last 200 years. Oh
yeah. Well, I mean, and I think the starkest contrast exists in the United States because of what the original intent was.
Oh, whereas, for sure.
Whereas in other countries, like, say, European countries that just started off in their ethos as, or not maybe started off in their ethos, but within the last couple of centuries have been more socialist or more kind of collectivist in their thinking and their organization. It's less noticeable, but I agree with you. I think there is a common thread of all of these things that we're looking at right now, happening to literally billions of people on the planet right now.
Yeah, absolutely. And it's, well, in a way, it's actually great because they just don't they just don't realize who they're messing with.
There's definitely a lot more of us than them, that's for sure.
Yeah, right, exactly. This is why it's so important to teach everybody, because as soon as people understand this, like, do you think a whole neighborhood going to the police station, wouldn't change some minds? Like, absolutely it would. But does that whole neighborhood, are they unified on a particular, political or legal philosophy? Well, no. A lot of them don't have this education. They don't understand we're at war. They think life is just fine. They're just living it up,
Yep. Yeah.
So let's see, where were we? So the following is just an article that I thought was poignant to show that kind of change of direction, kind of how far we've come. But this is an article from the Montana Daily Gazette. Feds confiscate guns in Flathead Valley with 30 vehicles, 3 tanks, and helicopter. Heretofore ignored by the legacy press and mainstream media, in February 2021, federal authorities invaded a neighborhood in the Flathead Valley, which you have to understand is like an hour north of where I live, with militarized police, and terrorized its occupants with what appears to be Waco-level tyrannical overreach. In the early Tuesday morning hours, motion sensors alerted the occupant, hereafter referred to as John Doe, names have been changed to protect the innocent, that there was movement along the driveway to his home. Given the time of day, the location of the home, and some recent history that will be discussed later, Doe knew he needed to react, but in a non-threatening manner. His decision was to put on a pair of pants, remain barefoot and shirtless, and move to the front of the porch with his hands raised in the air. So just imagine how obviously peaceful and helpless you are with pants on, no shoes, no shirt, your hands in the air. What appeared in the driveway was the lead vehicle of three Bearcat armored personnel carriers, commonly referred to as personnel tanks, in a convoy of over 30 total vehicles. The Bearcats are armed with a rotating turret for housing customer-specific weapon systems. 5 gun ports are located on each side of the vehicle, and an additional 2 in the rear. The vehicles are often equipped with .50 BMG, which is suited to take out like World War I era tanks and like planes at 400 meters, or 7.62 millimeter rifles. It's a military-grade vehicle often used by U.S. Special Forces and the Australian military. But on this day, they were cruising the Flathead Valley with 30 other police vehicles in tow. Also surrounding the house were 100 plus federal agents with a helicopter and support. Federal agents immediately took Doe into custody and placed him in loose-fitting flex cuffs in the back of one of the Bearcat vehicles. Inside the vehicle, John was placed on the outer wall, and at his feet were loaded weapons. Seemingly unbeknownst to the feds, Doe's 88-year-old mother, who suffers from dementia, was asleep in the house. The actual homeowner, Jane Doe, was also in the home. This is why Doe wanted to avoid confrontation and the stress of such an event by presenting himself peacefully. What looked to be a quick and peaceful resolution then took a strange turn to the worse. Why did agents breach the house when Doe was already in custody? Counter to standard practice, the team chose to enter a window next to Doe's basement door. That window is over 3 feet off the ground and thus difficult to breach and enter by a team that needs to move fast. There are many windows in the house that would have made a breach entry a lot easier. This window is different, not only in its height above the ground and the resulting impact on the tactics used, but it was also right next to Doe's bed. If Doe had not exited the house and moved to the front of the porch peacefully to present himself, the concussion grenade employed by the breaching team would have landed on him while he was sleeping. There's no telling what would have happened in that instant, but John's death is a possibility. It makes you wonder if that was their intent, right? Federal agents obviously knew the home's layout, and they immediately entered Doe's storage and security room and disconnected all security cameras while conducting a search. That's not legal. Though not included on the warrant, the federal agents searched John's gun safes, a detached garage, and vehicles parked around the residence. That's a violation of due process requirements and also not legal. Doe does in fact hold a federal firearms license, and is licensed for all weapons, ammunition, and powders on his property. Given this fact, federal agents can request to see all his material at any time, no siege required. So, honestly, what is the siege for? He presented himself. They have the legal right to enter his home without damaging a single thing whatsoever to go see all of that stuff. What is the purpose?
It sounds like, well, I don't know, so reading on,
what I was going to say,
the pretense under which it's done is shoddy, right?
Yeah, well, what I was going to say too is even if there was a justification for it, it still doesn't justify those 2 violations of the law that were just mentioned. Right. Cutting the security and violating the due process requirements of, searching beyond the authority of the scope of the warrant.
Right.
So, a restraining order, So the justification they have here, is a restraining order secured under false information in North Carolina, which caused a massive raid in Montana involving federal agents from around the country. According to the Constitution, federal operators may not engage in law enforcement activities without the permission of the local county sheriff, something that is often overlooked and ignored, which is the case here. And remember, that's an elected position. So guard that with your life.
Yeah.
Doe was not read his rights until 2 hours into the event. He was eventually transported to the Flathead County Jail by a deputy sheriff who was not aware of the preceding events until well after the fact. Doe was released 3 days later on his own recognizance. So we have the ability of immediate communication, right, with judges who can use the writs of habeas corpus to determine if there's a sufficient amount of evidence to charge him, to bring charges against him, or if there's not, and to release him. And yet he was held for 3 days. What is this?
Yeah.
Jane was never read her rights despite being questioned by federal agents. John, Jane, and John's mother were not the only victims of this raid. John's neighbor, who shares a long driveway with him, was detained in handcuffs for 2 hours as he left for work. Dude, you could be fired for not showing up to your job on time. Not to mention for, like a job like mine, the busiest and most, financially rewarding hours are the morning hours. They're the first hours when you get there. Yeah. So, you have no idea how much you have just violated this person. This is just
someone
insane.
Who's not even affiliated with it.
I know, he's the neighbor.
Yeah.
It's ludicrous.
Yeah.
I guess you have to know who you're going to live beside now? I mean, what the fuck?
We all have to do a home inspection of our neighbors to make sure that they're not going to be raided.
And don't be fooled by any federal firearms license or any legitimate paperwork or anything like that.
Yeah. No.
This last part's the worst, though. So a close friend of John's heard what had happened and was detained when he went to the house to check on his well-being. That's just like a stranger being like, oh, what happened? There's 800 fucking cop cars here and 1 million federal agents. And you're like, oh, well, we're going to detain you now.
God forbid he record his interaction with them as well, right?
Right, or anybody find out, yeah.
Yeah.
On March 5th, Doe and his neighbors both received mail that contained a list of confiscated weapons, but no ammunition was listed despite it all having been confiscated. So, theft? The list further contained only about 20% of the total number of items taken. Can you believe this shit?
Unbelievable.
The address listed on the paperwork was John's neighbor's house, and it remains unclear why both homes received the notice. As of the date of the publication of this article, there continues to be a news blackout of this event. And remember, this was in February 2021. This was not more than 4 months, 4 or 5 months ago.
Yeah.
John has not been charged with any federal crimes, gun-related or otherwise. Jane has had to pay over $4,000 in out-of-pocket repairs for property damage to her home caused by the breaching team and the subsequent search. Doe has had to pay thousands of dollars for legal representation. The feds spent thousands of dollars to execute this raid with agents from around the country, even as far away as Pennsylvania, Florida, and Virginia. Now that Joe Biden is focused on removing the Second Amendment from the Constitution, these actions could become the norm. And then there's an editor's note on the bottom. It says, the Montana Daily Gazette stands by the veracity of this report from a field reporter, and we believe the legacy press has been intimidated into silence by the federal government. Some pretty outstanding allegations. Sorry. So the next, this is actually a well-known Twitter user who you're familiar with, but I kept anonymous just because I wasn't sure if it was okay to reveal that. But we posted the following tweets. So from a neighbor's eyewitness report, quote, saw police at your house, your place. Police went inside your house. And, quote, some guy showed them a paper in blank. Police yelled police and went inside. They made the guy stay outside and then they went in. They went in. After a while, they let the guy in. They stayed there for a while. So then this is his tweets, this is his statement. Says, cops raided my house. Not sure why. At work right now. We'll let folks know how this plays out. Okay, update before I check every inch of my house. 2 vehicles. Neighbor couldn't see what police department. 4 cops. 1 unidentified woman. 1 plainclothes man with a piece of paper. Screen door fucked and barely hanging on. Latch not busted but forced. Nothing apparently missing. rifle messed with. Alarm clock, stove, and microwave are flashing time. So power went out for a second, or they were unplugged and moved. So it's probably just like before they were trying to disable any recording, anything that would catch their illegal actions. Live alone, door was forced, have a lawyer already, and have been in contact. No search warrant left. So, like, what kind of fucking dystopian nightmare are we living in? These are just two examples. These both happened in the last few months.
Yep.
Like, this is just, it almost just like beleaguers belief, right? That you're just like, is that even real? Because how could that be real?
So, what I always question is, all right, is this just more prevalent now because the actual actions are more frequent? Or is it more prevalent now because our ability to share this and uncover it is better?
I think it's more frequent. I'm sorry, I shouldn't have cut you off. I'm sorry.
No, that's fine. That's fine.
I think it's more frequent.
And it could just be both, right? But I personally, like, I know of a number of people now that have said that these things have happened and they resulted in no charges. So they're essentially almost like Gestapo intimidation technique, as opposed to, legitimate warrants with some actual teeth or presumption that something is going on that warrants them.
Absolutely. Like so like written here, I had, he doesn't know who they are, why they were there, and has absolutely no sense of security for his property or his person, since they seem to be able to act outside of the requirements of due process and without consequence. So like, this is just textbook, criminal actions taken under color of law, right? This is the thing that should have gotten an entire city riled up, like the Rodney King beatings.
Yeah.
Right. So this is the kind of thing that should never exist. The fact that it has become commonplace just goes to show how much the American people need a new identity to rebrand their concept of freedom. Because today, no one even knows what freedom is. No one even knows what what government behavior is unacceptable. They sit there doing nothing while this goes on day in, day out in their own neighbors' houses. So it's like, it hurts my soul that his tweet literally said, I'll let you know how this plays out, instead of round up your family and friends and all your neighbors. We're going to go down to the police department, right, and get some answers and hold people to account.
Well, I think what has also become apparent with our prior episodes of this series and leading up to this is, I think people still, the veil is dropping, but people still have a lot of faith stored up in the judicial system. And I think what you are in the process of uncovering is that they shouldn't, right? Like, or at the very least, they shouldn't have the faith in the justice system as it's presently constituted, right?
As it's presently infested with criminals.
Yes. And from that standpoint, I think the reason why these things play out the way it is and why neighbors don't get in an uproar as often as they should is because there is still some thought, and I think it's conscious, where we're talking about habeas corpus and essentially being able to punt for a year so that someone could essentially have what would normally be a protection invalidated simply by the timing of things. I think some of it is also intentionally baked in so that the timing allows the diffusing of the outrage, right? And it's always like, oh, okay, well, my day in court is coming, so hopefully I get justice. I mean, this is something that has played out with the court case.
I'm sorry.
Go ahead.
I shouldn't have cut you off, but it's just...
you had a visceral reaction. Go ahead.
I did, to let me have my justice, and it's just like, no. I'm demanding it. You're not going to stand in the way of the justice that is owed to me. I don't even understand another language or another concept. If you're not here to secure my liberty, and we're going to talk about this later with courts, how the judge himself is literally, quote unquote, the mirror of the king, that he is supposed to administer justice in the name or in the way of the king when the king is absent. So there's not supposed to be any lack of, justice anywhere. If you're not doing the justice bit, then you're a fucking criminal and you're going to jail.
Yeah, and
Yeah.
which by the way, in our society, and in a lot of other societies, these positions, and again, this has evolved over the period of time where we're looking at this. These positions were held to the highest standards of conduct, like in the
Yes.
past, or they were intended to
Yeah.
be.
They
And
were.
now, and nowadays, it's almost like the exact opposite. It's like when a mistake is made, it's assumed it wasn't intentional, and it's like, oh well, like they screwed up, they'll do better next time. Like they had the right intent, which is absolutely wrong. The way it was supposed to be, it was like when you were in one of these positions, the reason why you were deathly afraid of wrongfully convicting someone was because if someone called you on fraud, you could be hung, right?
Oh
Like
yeah,
that was
because
that
they're
was
coming
the
after you for
that
everything.
that was the
Yeah.
that was the like that's also why, and we can get into this at a later time, but like this idea of kind of like checks and balances that exist
Yeah.
within the Constitution
That's the
is
security of our government.
it is a lot of people defer to that, and you're like, you don't understand, it was never even meant to really get to that, right? Like the idea of three branches of government and checks and balances and stuff like that, like the federal government wasn't supposed to have that much of a place within our lives. And so if they were checking each other, they were checking each other on minor things. They weren't supposed to check each other on major things. The
Look,
major things, the check and balance was our intent to uprise if the federal government overstepped, which I think has been completely lost on people, like completely lost.
absolutely. Well, I was gonna say, the honestly, the whole purpose. I mentioned this before, but like the reason why we have the states and why we created the federal government is literally, like I keep mentioning, like we're at war.
Hmm.
It was there to fight the war so that normal people could just live their lives unaffected by how all these world foreign powers wanted a piece of it, you know?
Mm-hmm. Yeah.
And obviously, they started the war of infiltration rather than outright, butting heads,
Well, yeah.
and they
Well,
took over
if you
the apparatus that was created to protect us.
yeah, it's typical insurgency. If you can't overpower the enemy, then what you do is you'll infiltrate them from within
Yep.
and undermine them. Yeah.
Yeah,
No, it's
and we're
100%.
such a big thing. I even remember reading a quote from one of our founding fathers. I apologize, I don't remember who, but they were remarking, it might have even been Jefferson, remarking about how, because of how large our political institution is, it's like prone to not becoming corrupt because you couldn't corrupt that many. We have so many different political spots, like from local government to state government to federal government. It's just enormous that you couldn't corrupt every single one. And it's like a joke to that is just like, oh, you got a couple hundred years, you
Yeah.
know.
Well, I
So
mean,
what that means, though, is that it's going to be extremely hard for us to get it back because
yeah.
there's so much corruption we're going to have to deal with. But hey, I'm up for the challenge. Let's fuck all those guys.
Well, and Pete Quinones hit on this the other day with the one episode that I shared with you, and on some subsequent episodes within the last week that he's been talking, and he basically said like decentralization when it comes to the power being in the hands of the people is a good thing. When it comes to the government, like we have one of the most decentralized governments in the sense of it's everywhere, like it's in everything. So it's decentralized from the standpoint of it's not a monarch. It's literally 2 point something million employees and bureaucrats that are, doing all of this stuff. And so really at its essence, the problem that we have isn't that there's like 5 people to send to the guillotine and it fixes the problem. The problem is that we have a cultural issue that has been festering for 150 some odd years, maybe even more than that.
Well,
From
let me
1788, basically.
let me ask this though: if you do send those 5 to the guillotine, how many of them change their behavior?
I mean, that's a good question.
Because
I
maybe you
mean,
don't have to send them all to the guillotine, but that's an example you're setting, which I think is appropriate.
there is symbolism in it, and
No, not
I think,
symbolism. I suppose I mean the rule of law coming back.
I
You know,
mean,
you
you
have
basic,
reason to fear the law. If you're going to break the law, if you're going to violate people's rights, well, there we got a place for you. It's jail. Or if it's so heinous, we got another place for you. It's not living.
yeah. Well, no, I agree with you. It would have an effect. The question becomes, would it have an immediate effect that you would then have to kind of continue to replicate over time? Like that's the other thing is like the problems that we have now aren't immediate. Like it's they happened a little bit at a time and then all at
Yeah,
once, right?
yeah.
And so the question being, all right, well, what's the remedy? Is the remedy dramatic, kind of like this gigantic display of taking back liberty and then
No,
everyone else falls back in line? or
no.
do they lack the understanding? Like that's the other thing is, if those individuals that are kind of maybe unknowingly perpetuating the issues that we have currently, if they see that happen, I'm not sure that they're immediately going to run for constitutional law education. I think they're going to make up reasons, or there might even be like a direct response to it. So
Right. I
that's a big
honestly,
question.
well, I think that we can kind of look to our immediate history, January 6th, and
Yeah,
say, for one event or one kind of thing like that, that's supposed to be just like this huge revolutionary change, I really think is they've got their psychologists, their behavioral economists, they've got all these people there that are there to, man, they know how you're going to perceive, react, behave, etc. And they've got all sorts of plans for you. They've got all sorts of psyops and things for you. And that's not a you know what I mean? So not that January 6th was actually an uprising of any kind,
yeah,
but I'm trying to point out that, like, do you see how that's not the way? Because
yeah,
clearly they're ready for that, which is
yeah.
just going to justify the military, coming in and just fucking murdering people
Oh
just
yeah,
outright. Like, this is police, obviously, this is more local, to what degree, that makes a difference, I don't know. But you know what I mean? As far as the entire military being turned on us right now, it's just being used to guard the fucking Capitol.
oh yeah,
But so I don't think that's the solution. That's why we focus at ANRF is so much on education, because we really think that the youngsters who are coming up right now are going to be the ones who this appeals to. They're going to, like, we're going to be like, hey, did you know these are your freedoms? Because that's what nature has for you as a human being. And they're going to be like, well, I'll be. And then we'll
yeah,
be like, oh, hey, look, this is how you could, possibly secure it in one way.
yeah,
And they'd be like, well, let's do it, and then those
yeah,
people who are judges and, like I've said before, judges and lawyers and even politicians, people who are in high school or in college or postgraduate right now, who we could teach and explain how the law is. And maybe they're good people and they just don't understand. There's so much propaganda out there, as you've
yeah,
seen, right? So much sophistry that takes this legitimate liberty, freedom of humankind through the law, and just completely perverts it into this abusive, slavish system that, like, if people just knew it, I really think there'd be a drastic change in a lot of the people in the government, because a lot of them, I think, feel bad. I heard an account of one soldier one time talking about how one of the first things that happens, I think, after their basic training was a seminar that they took, where I don't know if it was like it was at West Point, I think they were saying, in some particular professional was, and when I say professional, I really mean some high up military person that they would respect and admire and believe and trust, basically gave a lecture on what it means to defend the Constitution. And right in there, they specifically regard the opinions of the Supreme Court to be what the Constitution means. So if they were to have things like Taylor's, what Taylor showed about the truth about the Constitution, about the Supreme Court and stuff, it would make such a drastic difference. You see what I
yeah,
mean? No war, no fighting, or they come to our side. You
yeah,
see what I mean? They never wanted to be on the other side. They literally, this was like a thread. It was a plea saying, like, I'm sorry,
mhm,
if I had another way, I could, but this is why sophistry is such a fucker, because
yeah,
it's like the human mind is so apt to being reasoned with out of its liberty that it's like, oh man, and now to be taking the liberty of other people, it's just hardcore. So we have to guard, education and the information. Got to teach everybody.
yeah. Most definitely, most definitely. So let's keep plugging along here.
Yeah,
So
sorry.
No, that's okay.
So to finish off about habeas corpus, the only Congress has the power to suspend the writ of habeas corpus, either by its own affirmative actions or through an express delegation of the executive. The executive does not have the independent authority to suspend the writ. So what Lincoln did in suspending habeas corpus was actually illegal, a violation of his oath, and an act of treason because it was unconstitutional. So trial, just I guess we can just keep plowing through. Sorry, I know I took a lot of time for commentary, but
no, that's right.
Trial by jury. So trial by jury is another constitutional protection for the rights of the people. By assuring that the people themselves participate in the judicial process, governing authorities are prevented from unjustly prosecuting individuals. Trial by jury assumes that the people themselves are the best guardians of their own rights, and that they will release from custody any person unjustly charged. It also allows the people to make unjust laws of no effect with their power of jury nullification. In a letter to Thomas Paine, Jefferson concluded, "I consider trial by jury as the only anchor ever yet imagined by man by which government can be held to the principles of its constitution." And in response to a question put to him about a particular book concerning Spanish republics, Jefferson would say, "We think experience has proved it safer for the mass of individuals composing the society to reserve to themselves personally the exercise of all rightful powers to which they are competent, and to delegate to those which they are not competent to deputies named and removable for unfaithful conduct by themselves immediately." So there's a clear line, right, that you can draw between legitimate and arbitrary governments, right? Anything on or anything within the scope of, what did it say? The exercise of personal competency would be an invasion of an arbitrary government, right? Hence, with us, the people, by which is meant the mass of individuals composing the society, being competent to judge of the facts occurring in ordinary life, have retained the functions of judges of facts under the name of jurors. And in his first annual address, he said, "It will be worthy of consideration whether the protection of the inestimable institution of juries has been extended to all the cases involving the security of our persons and property." So meaning that you were supposed to have the protection of trials, get this protection of trial by jury every single time it implicated, person or property. Their impartial selection also being essential to their value, we ought further to consider whether that is sufficiently secured in those states where they are named by marshal, depending on the executive will, or designated by the court, or by officers dependent on them. So Jefferson was, equally concerned with the selection process of juries, and today, basically, lawyers, they just use it as, it's just become a system for them to abuse the law.
Yeah. Well, and on top of that, there's also a lead up to, I think, the overall proportion of cases that actually see a jury trial have been has been ridiculously lessened because of just how the judicial system and the justice system has been constructed. It's constructed more as a factory than it is an actual finder of truth and justice. Like it's more predicated on throughput than it is on actually finding the truth of a matter.
Yeah, because it's a cashier.
Yeah. Yeah.
That's what it is, basically. It's there to scan your items and take all your money. Although you don't get to take any items, the items are metaphysical jurisprudence that it argues through sophistry. So.
Yeah. Well, no, it's you walk by, you scan your wrist at the cashier, and they reach into your pocket and take your wallet out. Is basically what happens.
And if you don't come to the store, we're gonna bring send our thugs with their guns and their handcuffs, and you can have some fun. We'll shoot your dog.
And then you can never leave the grocery store again. That's basically what it boils down to.
Oh, jeez. All right, so where are we?
Jury nullification.
Yeah, jury nullification. So this is in a letter basically articulating his views on the institution of juries, in which he enumerated a series of legal authorities concerning the subject. So to me, it's just like a letter. The beginning is just a list of books, and then he says, "These are all the books that I have on juries," and then he's like, "These are what I know about juries." So it's a very substantiated articulation. But this coming from Jefferson, he said, "It will be worthy of consideration whether I messed that up. It is left to the juries if they think the permanent judges are under any bias whatever, in any cause, to take on themselves to judge the law as well as the fact. They never exercise this power but when they suspect partiality in the judges, and by the exercise of this power they have been the firmest bulwarks of English liberty. So in his notes on Virginia, if the question before the magistrates is a question of law only, they decide it on themselves, so long as there's no bias or partiality. But, and remember what we talked about with realism, right? That thought, school of thought was concerning, American jurisprudence and the judiciary. Mm-hmm. The idea that a judge does use bias and his own personal opinion to make the decisions. Mm-hmm. Look how ludicrous that is. In every instance that could be shown to be or suspected to be the case, the jury is there to decide, it.
Well, and also to essentially nullify that, so essentially the idea being that if the magistrate or the judge in any way is biased against the defendant or operates without honor within that entire proceeding, the jury is there regardless of whether or not they feel like the individual is guilty to essentially nullify any kind of verdict against that defendant, because even if they were guilty, you could never have a reasonable conclusion that they were because of the bias of the proceeding. Does that kind of make sense?
Yes. Are you saying that's what this is saying here?
Well, I'm saying that this seems to be the direction it's at least leading me in, is this idea
what this is referring to is that the juries basically hold an original right to judge the law in all matters. And that this right is generally given to the judges to decide the law. And they take that right back as soon as they have any suspect of bias, and you're going to learn later when it implicates the public liberty. So, it's a lot of, here, let's get to it. But if it be a fact or a fact and law combined, it must be referred to a jury. In the latter case of a combination of law and fact, it is usual for the jurors to decide the fact and to refer the law arising on it to the decision of the judges. But this division of the subject lies with their discretion only. And if the question relate to any point of public liberty, or if it be one of those in which the judges may be suspected of bias, the jury undertake to decide both law and fact. If they be mistaken, a decision against right which is casual only is less dangerous to the state and less afflicting to the loser than one which makes part of a regular and uniform system. So I included information about the following case to kind of show you what Jefferson means here.
Okay.
So in Wickard v. Filburn is a United States Supreme Court decision that dramatically increased the regulatory power of the federal government. It remains as one of the most important and far-reaching cases concerning the New Deal, and it set a precedent for an expansive reading of the U.S. Constitution's Commerce Clause for decades to come. An Ohio farmer, Roscoe Filburn, was growing wheat to feed animals on his own farm. The U.S. government had established limits on wheat production based on the acreage owned by a farmer to stabilize wheat prices and supplies. Filburn grew more than what was permitted and was so ordered to pay a penalty. In response, he said that because his wheat was not sold, it could not be regulated as commerce, let alone interstate commerce, described in the Constitution as commerce among the several states. The Supreme Court disagreed. Quote, whether the subject of the regulation in question was production, consumption, or marketing is therefore not material for purposes of deciding the question of federal power before us. But even if appellee's activity be local, and though it may not be regarded as commerce, it may still, whatever its nature, be reached by Congress if it exerts a substantial economic effect on interstate commerce, and this is irrespective of whether such effect is what might at some earlier time have been defined as direct or indirect. The Supreme Court interpreted the Constitution's Commerce Clause in Article 1, Section 8 of the Constitution, which permits the U.S. Congress, quote, to regulate commerce with foreign nations and among the several states and with the Indian tribes, end quote. The court decided that Filburn's wheat growing activities reduced the amount of wheat he would buy for an animal feed on the open market. which is traded nationally. Here, let me restart that. I'm sorry. The
That's right.
court decided that Filburn's wheat growing activities reduced the amount of wheat he would buy for animal feed on the open market, which is traded nationally. It is thus interstate and is therefore within the scope of the Commerce Clause. Although Filburn's relatively small amount of production of more wheat than he was allotted would not affect interstate commerce itself, the cumulative actions of thousands of other farmers like Filburn affect interstate commerce itself. I'm sorry. The cumulative actions of thousands of other farmers like Filburn would become substantial. Therefore, the court decided that the federal government could regulate Filburn's production. So the mere fact that the question before the court was one related to public liberty, right, essentially concerning the right to use your property on your own land without, unimpeded by the state, meant that it was for the jury to decide, right? And there's a concept related to courts that's known as dignity. And so this refers to that hierarchy of law that we talked about before. But basically, courts of law, and also known as courts of record, are courts of superior dignity, and courts not of record are of inferior dignity. So essentially, the appointed judges of the Supreme Court would have had no jurisdiction to redecide a matter already decided by that superior court. So let's see. Oh yeah, not to mention that the opinion itself admits of bias, right? Because it's literally because it's not based on any aspect of the rights of the parties in the suit. It's actually based on the judge's personal opinion about the effects of deciding on the case according to Filburn's rights and traditional American jurisprudence.
Right.
Right. So that alone would invalidate the ruling and cause, I don't even know, because it's obviously it wouldn't have gone to the Supreme Court. Like if a jury had a capacity to determine, the situation in the matter, obviously they weren't given that right. That's why, judgment after judgment after judgment went up to, it ended up in the Supreme Court. But our juries definitely would have protected against this kind of, abuse of the system had they been in the informed of their right to judge the law in the matter.
Yeah. Which also, now correct me if I'm wrong, but this also comes to the discussion that we had earlier as far as whether or not you are informed of your, when you're putting in a plea, right, or you're undertaking an action within the court, are you unknowingly, unknowingly recognizing a form of court proceeding that you don't necessarily know that you have a choice between, right? Does that come into play in this case, at least in the lower courts before this ruling? Because it sounds like that this entire process was more, it was essentially just magistrates or judges that were included in this entire decision-making process. Was there an opportunity that was unknowingly foregone to have a jury trial that didn't, enter into this case?
I'm not sure if I understand your question. Is there any chance you could rephrase it for me?
So, for instance, it sounds like essentially when this case goes through its paces, there was no room for a jury to ultimately check the biases of the magistrates that were included in this, right?
To be honest, like I talked about before, with lawyers going to law school, learning how to plead in equity, basically, they don't learn about the law. They don't learn about, common law jurisprudence. They learn about equity jurisprudence. And so then, these people become judges, and these judges obviously don't have any education on the matter. And like I've mentioned before, in an equity court, it is appropriate for the judge to be the tribunal. But in a court of law, there's that separation between the magistrate and the tribunal. And so the jury is required, in a court of law to be. So like this, you can understand, when are we reading these from?
Right? What it's essentially saying, what it sounds like is this is a court ruling that is more akin to an arbitrator arbitrating than an actual finding of law. Right, it sounds like a it sounds like essentially the judges um, enforcing their opinion or using their personal bias and opinion to reach a resolution in this case, as opposed to a pure finding of legal precedent. Does that make sense?
Well, yeah, but the reason why that might be is just because the Supreme Court doesn't have original jurisdiction in a lot of cases, so that means that they have to start in other courts. There's no jurisdiction to begin in the Supreme Court. They have an appellate jurisdiction in a lot of instances, and so that's why I was saying, like, if the jury was empowered in the previous case, or in the case that this is the appeal for. Right, or whatever case was before that, because there's appeals all the way up, in state courts and everything. I haven't followed this case. This is just an example, of that. I didn't follow the history of this case. I just followed the Supreme Court on this. But basically, because the Supreme Court is an appeal, has appellate jurisdiction, it's essentially that they would be ruling on whether or not, the law was strictly adhered to in those other courts, right? Okay. And so whether the judge did or didn't adhere to the law, right, is just a matter of seeing whether he did or didn't. But it was never determined whether the jury was there saying, "Okay, judge, we're going to let you choose to judge in this matter," right? And I would argue that it's not, because what I was saying before is this idea about these legal professionals, they're judges and everything. They don't understand that in a court of law, it's actually a requirement for the jury to give you the discretionary authority to judge the law, right? It's not actually your original right. It's a privilege as a judge that you're given by the jury at their discretion only, right? But I've heard judges on record saying, don't concern yourself. I will instruct you as to the law. Like some of these tax cases, it's insane, and so it's just the idea, that the Supreme Court is now over here, giving some final kind of say. It's just all a bastardization. You know what I mean? If the people understood, if you were a jury member and you understood what your right was, what would you say to a judge? Hell, I'd be like, "Excuse me, who do you think you are?"
You're not going to tell me.
Yeah.
How
well,
to.
Like, here's the thing about this too, is like, while it is over here that these quotes are coming from Jefferson, and Jefferson cited these sources, right, which are like English and early American authorities, they're not the case that usually gets referred to. It's like Jones v. Jones. I can't remember the citation, but in that particular case, it's established that a court of law or court of record requires that separation of the magistrate and the tribunal. So as far as I understand, because of that precedent, our legal system does not allow for the judges, even in those instances when they're not biased and there's not suspected of bias and it doesn't implicate the public liberty, they still don't have the authority to judge. But this is why this research is so important, because you have to really get into the depths of what everything is and what's really true and what's really controlling, because a lot of stuff just acts like it's what the truth is when it's really a perversion of what actually is true.
Yeah, and this next quote seems to kind of lead in that direction too, right? Jefferson's essentially saying that it's only when the jury chooses to kind of pass off the judgment of the law to the magistrate that it's actually valid, right?
Yeah, this right here. The juries are judges of all fact and of law when they choose it. But like I was saying, that predates, that's 1816. But this is Jones, and there's a number of cases cited that cited that case that gave it, weight at law basically as a precedent, which state that, you can't. A substantive requirement of court of record is that there's a separation between that magistrate and that tribunal. So even though Jefferson references these things that say it's a choice, it's almost like it's been established as precedent that there is no choice. It is for the jury to decide.
Yeah. Okay, fair enough.
So yeah. So
here we have what may be my new favorite phrase, esprit de corps.
I think we have one more paragraph here. That kind of, I think it's pretty important. Basically, just like Jefferson warned of you know how we heard that phrase permanent judges.
Yeah.
So Jefferson warned of issues with permanent judges. Those are people who are elected, right, or appointed, and then they are the judge forever. Whereas before, when you had a dispute, you used to just, with the person you had a dispute with, voluntarily choose a third party to arbitrate your dispute. So you didn't have a permanent judge. In every instance, there was a new judge to do it,
Yeah.
But in fact, one of the issues was finding proper judges. And so that's why we actually instituted having permanent judges. But yeah, so Jefferson, remarking about the issues with permanent judges in a letter concerning that same understanding about juries we were talking about, he said, we all know that permanent judges acquire an esprit de corps. That being known, they are liable to be tempted by bribery, that they are misled by favor, by relationship, by a spirit of party, by a devotion to the executive or legislative, that it is better to leave a cause to the decision of cross and pile, which is basically just like the flip of a coin, than to that of a judge biased to one side, and that the opinion of 12 honest jurymen gives still a better hope of right than cross and pile does. So, like, hopefully you're starting to see how trials by jury and jury nullification are a very significant aspect of the protections and securities of our government. So, yeah, Esprit de corps, I just included this because he mentions, permanent judges acquiring the Esprit de corps. And basically, I think ANRF sees this as one of the main issues in government today. But this isn't some final say. This is just like a few aspects articulated for the sake of it. So I mean, this is by no means the be all end all of Esprit de corps. It's legitimately like a very brief, just give you an idea of what this concept actually is referring to, because it has some very significant impacts in practice. So Esprit de corps is the degree to which a group feels a sense of unity and motivation to achieve a common mission. This is an old French military term that can be literally translated spirit of the body. The following are aspects of Esprit de corps. Camaraderie is a sense of trust and friendship that develops within a team. This emerges over time and is increased by meaningful shared experiences, such as overcoming difficulties together. Identity, the degree to which members of a group view this membership as important to identity. For example, individuals who view their profession as an important element of their character and social status. Pride in the accomplishments of an organization or team. For example, an individual who is proud of being a student at a well-known university. Abundance mentality is the degree to which an individual is happy to see others succeed. This type of win-win outlook, and Esprit de corps, this is a type of win-win outlook. An Esprit de corps implies an environment whereby people support each other's success, and in the alternative, protect each other from the consequences of failure or their own wrongdoing. And so for the government, that means, success in trampling your rights, and protection from the consequences is things like one cop providing false testimony to cover his colleagues, or the commonplace abuse of qualified immunity that we see today. Motivation is the energy that the individual feels toward a purpose. Esprit de corps implies an intrinsic motivation whereby groups feel a strong need to reach a goal, regardless of associated rewards and penalties. Corporate narcissism is when group pride goes too far, such that an organization is overconfident. This can cause a neglect of risk, poor judgment, unrealistic strategy, and antagonistic relationships with stakeholders. And that's just those who have an interest in the performance of the body, right? So, which for our government is obviously the people.
Right.
Corporate narcissism creates an inability to recognize failure, such that losing strategies are continued until they become enormously detrimental. So, like, think of, police escalating the situation instead of de-escalating. So now that you understand Esprit de corps, right? I would ask you, is there an Esprit de corps operating in our judicial and executive branches of government?
Yeah, most definitely, and I think it is the worst realization of it.
Yeah.
I mean, it takes on the form of essentially a collective with a hyper concentrated amount of power, whose esprit de corps is essentially causing them to act regardless of, what was the phrase? Regardless of the associated rewards and penalties,
Yeah.
specifically the penalties, right? Like there is such a motivation to act not in good faith, I guess, as a part of this collective, that even potential penalties, which I think we've shown should be much more severe than they are now. Even the potential penalties are no deterrent from their
Well, they're not
conduct.
really enforced. Like I
Yeah,
just, those two examples we went through of, up in Flathead Valley in Montana, of those feds, that entire mess, plus this guy, who I believe ran for office and is now being targeted by who knows what police department on what shady kind of,
right.
people, can just break into your house, break your stuff. Like, I don't even understand what we're talking about anymore. This is like the most ludicrous stuff
Yeah,
in the entire world. And yet the reason why these people who do these behaviors don't see it as insane is because of esprit de corps.
yeah,
Yeah.
yeah. I
It's
mean,
it's hard.
it's a it is a fussy French way of saying mob mentality. Is basically what it's saying.
Um, I don't know if
Or
it's mob mentality as much as it is just like the feeling of being, you know, like identified with a group, the
yeah,
feeling of these are my people, you know what I mean?
yeah,
Like,
and deriving some level of uh, pride, or
an obligation and
yeah,
duty.
yeah,
Yeah. And protection and need to protect and all of these things, which you should not do if you're a public servant,
yeah.
if you want
It,
a non-corrupt, good performing government.
well, which is interesting, because the one of the things that you covered earlier up here, we were talking about like the propensity, at least a while back, or the intent, where disputes are much easier to resolve if the two parties decide to just bring in an unaffiliated third party to, be the arbiter of the dispute. And instead, we've created essentially this institutionalization of everyone running to the court system to fix problems. And that was not the original intent. The original intent was two individuals operating in good faith, and if they couldn't come to a resolution themselves, bringing someone else who came in, and I believe it was, operating with honor, right, and
Yep.
acting with honor
Yep.
to be
Exactly.
able to resolve something.
But you shouldn't distinguish it from the court system because as as you might remember before, we talked about like this legal procedure, this legal process that you might
Mhm.
refer to as the common law. It's essentially it was used before, like, okay, so you've got areas where it's not the United States, it's there's no established territory of what it is or anything, and yet you've still got the adherence to the the common law, the use of the
Mhm.
common law by a group of people who create a town. And I don't mean create in the sense that they incorporated or there's any kind of governing anything. I just mean they literally are people living next to each other in the state of nature
Yeah.
and utilizing this system of securing their rights, right?
Mhm.
It was there. And then in these places that were federal territory before they formed into states, that was the process those individuals used. That was the common law was the court system that they
Yeah.
used to settle disputes. And in the states themselves, the ones that were formed, that were colonies and then became independent states, they themselves upheld the common law. So there's like it okay, Jefferson said a phrase. I think it was like, I can't even remember because it was like Richard Dawkins or someone like that who gave a speech
Mhm.
about Jefferson and how he sent like a convoy to meet with particular Indian chiefs on the west coast,
Mhm.
and like he said to tell them, gentlemen, welcome to America. And it's almost like if you have this idea that you have a foreign nation, right? And then you've got a new nation that just stole all the land from the foreign nation. And now they're sending a convoy to say, welcome to America. And that's not somehow like an offense that would cause a war between those two. It's ludicrous, right? But if you
Yeah.
understand the actual relationship that the government, the American philosophy, political philosophy, which underpins the government, means that you have no obligation to the government, yet the government provides protection to you. You have no duty created in return, and yet you are offered all of this protection in the form of, look, the legal system, if you so choose to use it to settle disputes. But especially like you're saying, that's why I was trying to say you don't distinguish between the two, but especially like you're saying, if you don't even have to take it to court, if you just act in honor, and if I mess something up and you told me how I messed it up, I'll be right there to try to fix it and compensate for it. And I'll make sure to look out for that next time. We don't need to go to court. You don't need to get some group of people to tell me how to do it. I'll do it. You just tell them, And so this is how moral people with honor, would basically avoid any issues, or, if you said that I did it and I was like, I really didn't do it. Like I'm talking to my wife, like, he thinks I did it, but I really didn't do it, And I go to you and I go like, hey man, I know that you think I did it, but I honestly didn't do it. A moral person with integrity and honor would say like, you really didn't do it, Like there would be trust and a belief, and that's where that idea, what you were saying, of good faith coming in, right? That you're not coming into the situation thinking the person is a fraudster, you know what I mean? That they've got malicious intent, but rather we're all trying to be good people to not have to create a political society to enforce any nonsense, Yeah,
no, completely. All right, I don't want to rush you through this part. I have like 15 minutes, so
shoot. Okay, I'll try to just read it real quick. Sorry,
no, that's okay. But so we have the summation here in terms of the problems with this,
right. So these are the problems that the ANRF is trying to solve, right? So the American Natural Rights Foundation recognizes inherent problems with Americans' current ability to assert their rights, protect against violations of those rights, and seek remedy for such violations. As such, the ANRF is intent upon aiding the fight against crime and injustice, government extortion, and esprit de corps, but most importantly, the ideational poverty of Americans concerning conventional American political and legal philosophy, as well as legal process. So our mission statement is to realize the promise of freedom for all Americans, both natural and political. We strive to rebrand and renovate the reach of protection subsistent to the inalienable rights inherent in every human being, as well as its mirror in American law. ANRF accomplishes this mission through three main pillars of active responsibility. Research. One, research. Legal, historical, sociological, and philosophical. Through research, we will substantiate what was long established and what our founding fathers envisioned as natural rights, and at the same time, what the law truly is. Second, education. Educate the public, educate the government, augment academic curriculum. Through education, we will make efforts to teach the adult public what they need to know about their natural rights and how to assert them. Additionally, we will inform the next generation of lawyers, judges, prosecutors, politicians, etc., just what the law truly is by attempting to educate younger generations through a partnership with public and private institutions of education. And third, advocacy. A mediator of civil dialogue, approach government in behalf of public, assist private individuals with their specific case needs and inquiries concerning rights and liabilities. Through advocacy and as a mediator of civil discussion, we will foster communication that will lead to a better performing public servant and a more relaxed, happier public. The general objective would be to network and dialogue with members of the judicial and executive branches, creating a civil rapport to aid the public in their assertion of natural rights and the American political, statutory, or common law equivalent. The ANRF is currently concerned with the following 5 areas of focus: paternal rights and assistance, Department of Corrections, impoverished communities or individuals, individuals with mental illness, and most importantly, courts and enforcement, so Department of Justice and departments of the executive branch. We want to provide an environment that basically supports and encourages the use of the law to secure your liberty and the adequate performance of public officials. And our plan is to basically provide the following structure of activities for people to be able to do this.
Okay.
So starting off with research, the ANRF will eventually employ 3 paralegals, 1 historian or legal professor, and 1 professor of law to research relevant legal, historical, and philosophical information. This information will then be utilized by other activities of the ANRF. Educational meetings. We want to provide monthly or bi-monthly meetings where our employees or volunteers educate the public in the following areas: civics, that branch of philosophy dealing with natural rights; standard and fundamental concepts concerning American courtroom process and legal procedure, and any other aspect concerning the assertion and preservation of rights. Production of materials. Our idea is to have experienced professionals making educational materials from research produced by our research activities. This material can be used during educational meetings, handed out to the public in printed pamphlets or handouts, posted on our website, and on numerous social media sites and apps. It could be released as a documentary, film, podcast, meme, or any other form of illustration, expression, or publication of the like. Providing interviews. Representatives could participate in interviews with various outlets of public news, discourse, or information through in-person, teleconference, or even radio and podcast interviews. Private and public curriculum. So we want to employ an academic advocacy team, and this would include professionals called instructional designers. And these are people who have degrees in basically creating textbooks and instructional programs. So we would employ these people in the creation of and continual development of curriculum designed to educate the public through public and private educational systems. We would include K through 8, or which would include K through 8, high school, university, and postgraduate level institutions. This curriculum would be varied depending on the grade levels of any given institution and may include public agencies such as police academies. Public dialogue. We'll have an education team open dialogues with the public, possibly including personal discussions that might take place at outreach events while handing out materials through the use of surveys or polling, when going door to door, and through social media. And academic advocacy. We want to have a specialist group whose membership would include retired school board member and a retired education administrator to approach educational institutions to aid the adoption of ANRF educational curricula. This group would act as liaison to our partners in private and public education, and they would advocate for the public's need for education in the subject of civics and legal process to that end. Executive and judicial advocacy. Another specialist group, including retired law enforcement and a retired judge and a professor of law, would formally approach local, state, and federal agencies to speak in behalf of the public. This group aids the reception of curricula and informational materials by agencies or agents of government. Additionally, they work closely with agents of law enforcement to find a desirable middle ground of understanding, communication, and dedication to the proper enforcement of law. And that's, basically everything we've been talking about, like how it's been construed inappropriately. So the proper enforcement of law would include all these things we've been, discussing through all these episodes. But basically, this aspect is necessary because if a judge isn't just outright pissed off about you defending your rights, your case, he probably isn't going to even understand the law that you'd be presenting to him anyways. So essentially, to save your time and to make it easier to aid the reception of the practice of law based on natural rights, we think that this we want this advocacy to be an aspect of the work that we're doing. So legal advocacy, this is the last activity. We want to make expert professionals available to help educate individual members of the public to aid them in their effort to assert their rights and effectively litigate their causes of action. So that could be in a classroom setting or maybe on a one-on-one type situation. Mm-hmm. But we currently have many roles for volunteers who might want to get involved. If you like to fact check claims, or verify wholesale narratives, if you like to do historical research, if you like to research our American history of subterfuge and usurpation, if you enjoy legal research as an amateur or if you're professionally qualified, know about business, operations, management, or office administration, if you have experience in accounting, like to solve problems, develop programs, or manage systems, have funds you want to contribute to this idea or our efforts, study natural law or resource-based economy, economic theory, if you like to study deontology, the science of ethics, duties, and rights, if you like to study science, human behavior, sociology, or the natural law, if you like to discuss politics, agorism, ANCAP, or even anarchism to a certain degree, if you like to be on social media, make connections, and talk with people, like to create content, blog, or provide commentary on current events or important topics, if you have experience in website design or maintenance, coding, or networking, if you're interested in liberty and want to help develop a means to enforce and secure it, if you're well organized, self-motivated, intelligent, and will stop at nothing less than the full liberty of free people and accountability for those bound by oath to their particular performance, or any of the things that I just listed, then we want to hear from you. The vision of the American Natural Rights Foundation is to see Americans enjoying the sum total of their legitimate liberty, as well as to turn the tide of privilege that is so inexplicably woven itself into the identity of American government, such that the public servants once again serve the public, and the members of the public once again reign over their servants of government. ANRF is dedicated to the liberty of all humans.
I love that. That's some people might think it's like an editing thing, but I think it needs to live there on the last page by itself, just as a sentence. I love that. No, I'm super excited. I'm really glad that we were able to link up and that we were able to connect, because this is the birth, I guess, of this foundation, or at least you're in the early years of this foundation, and this is going to be a long-term commitment. It's a big undertaking.
Yeah.
And so I would tell anyone who's watching or will watch this in the future, if you have any kind of interest in being part of this movement to help fix what is pretty much, we've displayed is like really broken, like a system that is extremely broken.
Corrupted. Not broken,
yeah,
corrupted.
Well, yes, yeah. Or co-opted, I guess I would call it. But yeah.
Usurped.
Yes, if you are interested in kind of fixing what is wrong with this system, definitely reach out. And I love that on all of our pages we have the Proton Mail email address too. So
yeah,
y'all can
reach
out that
direct
way.
Contact to us right there.
Yeah. So, no, that's
awesome. And there's
awesome.
also a number on our webpage if that interests you.
Yes. Yeah. I would implore anyone who's interested in helping out, please reach out. If you don't want to be a masochist like myself and try and put together content or something like that, but you do want to be a part of the movement, this is a definite way that you can get involved.
Hey, even if you want to put together content.
And if you do, yes, become a part of the organization as well. I love the fact that you put in there memes. Meme magic is real. I love that. My first thought was just, taking some of Jefferson's quotes from this and putting it on recognizable photos of the quotes obviously not being adhered to.
Yes. That'd be awesome. That'd be great.
Yeah. So, look, definitely reach out if you are looking to get involved in this movement.
Yeah. We're seriously excited to hear from you.
Yes. Yeah. And we are going to be, this is, again, the soft launch, July 12th. We will be talking about deschooling, which, by the way, a component of the mission of ANRF is going to be the education process. I want to start, just from this episode, when my kids have a conflict with each other, I want them to agree upon a unaffiliated third party to arbitrate the dispute. That's what I want.
Wait, only if they can't work it out themselves.
That's true. Yes. Yeah. Not as the default. Yes, I agree. Yes. Yeah. If they reach an impasse. Yeah. And
not me. That's a great idea, right? Because it avoids all conflict. Because you both can voluntarily agree to be bound by the decision.
Yes. Yeah, and not me or mom, because we're obviously not biased.
You need a jury of 12. No.
Yeah. There's going to be stuffed animals lined up on the wall, I think.
Hey, man, if you teach them young, hopefully they'll stand, actually not hopefully, I know they'll stand by it. That is the hope, and we're going to tackle one of the, on the 12th, we're going to tackle one of the things that I think is probably the most important, and I know, Josiah, you came through this route, not necessarily ascribing your kids or handing them over to a centralized education system, I think is one of the biggest steps. Or at the very least, we're also going to look at how, if you are a parent that can't necessarily take your kids out of public school or centralized education, how you can work within that system to at least kind of fix some of what's broken within it and work with it. I know you have to go, but can I make a comment on that?
Yeah, go for it.
What we used to do here in America? We used to pool people who had children who needed education, used to pool their money together and hire a particular individual they would all have a meeting and a discussion about the curriculum to teach their kids and what manner they would teach them and everything. Like, there's not, like, a very intelligent individual who really wants to make a super impact on the situation could facilitate people getting together to pool their money for agents to come as, just contracted individuals to come and teach their kids, so that you could actually still outsource. It wouldn't be centralized because it's essentially, and you've got a direct control over that curriculum being taught because you can pull your money out right away. You know what I mean? I'm not putting any more in. I'll go with this group or that group, or maybe it is best for you to do your own schooling or whatever. But, I mean, imagine how much more it would catch on to get people out of this government fuckery to just, free them, because obviously not everyone can take on educating. It's a deal. It's a whole deal to educate, as obviously, to educate kids. I don't even have kids. I'm sorry.
I mean, what you're describing is the present day co-op. I mean, that's basically what it is.
Oh, does that exist? That's so cool. I didn't realize those existed.
So there are tons of homeschool co-ops, and where they will actually pay either a full-time person. It's actually more common that the parents kind of take turns in doing some of the schooling, and then also they will occasionally pay like an outside tutor, or it happens with the arts a lot. Like they'll bring in someone who's like a teaching artist to teach the kids and stuff like that on a contractual basis. Completely self-funded, voluntary. It's so we're going to be talking through some of those options.
That's awesome. Yep. Oh yeah, that's so cool. I can't wait. I won't miss it.
I'm biding my time. We got about 2.5 weeks here. So.
Oh man, yeah, a long time.
Yeah.
Well, I guess I'll see you before then, probably.
Yes, and we will have another one of these coming up. So I'll make sure to telegraph that online and everything like that.
If everything goes according to plan, we're talking about the Civil War next. And I think it's going to be either 2 or 3 part series. So.
There's going to be some meat on that bone for us to to chew on a little bit.
Awesome. Thanks so much, Matt.
With that, thank you very much. Appreciate it, Josiah. Have a good evening.
You too. Thanks a lot.